conclude, I think, the discussion on the Deeds Registries Act. And then I think I'd like to discuss with Mareka. Mareka, I think, was involved in updating the notes on sectional title. She's more of an expert, I think, than I am. And Mareka, if you want to take over on Saturday on sectional titles, then by all means be my guest, and then we can see where we go from there. So guys, not to disrupt the momentum, I am going to try and finish off the two chapters on Deeds Registries Act, and on Saturday you'll do sectional titles with Mareka. Mareka, thanks. You've got a lot of nice examples to give to the students as well, far better than the ones that I think I have been circulating. So again, if I could hand over to you to give everyone all the relevant examples that we touch on this evening and going forward. Okay, guys, just before I go on to deal with the disposal of mortgage bonds, I'd like to just recap on some of the things we touched on in Saturday's lecture on mortgage bonds. And I think I mentioned that there's no prescribed form for a mortgage bond. The registrar will not examine any provisions relating to a bond which are not relevant to the registration thereof. So in other words, the Deeds Office will not check the terms and conditions of a mortgage bond, but will only satisfy itself that the document concerned constitutes a mortgage bond in compliance with the Deeds Office requirements. So the provisions and content of the bond are in the discretion of the conveyancer, and it's his responsibility or her responsibility to ensure that the contents of the mortgage bond are correct and unambiguous. So as we know, when the conveyancer signs the preparation certificate, he accepts responsibility for the facts contained in the bond. And he must ensure, and this is important, that the necessary authority has been granted by the mortgagor, where the mortgagor is a company, a closed corporation, or a trust. That authority has been given to the representative signing the power of attorney. As you know, and you've dealt with this on the chapter dealing with FICA, that the conveyancer needs to obtain documents and information to satisfy himself or herself as to who the mortgagor is, and that the mortgagor is authorized to register the mortgage bond. Obviously, in the case of a natural person, you'll get a copy of the ID document and marital status. But where the mortgagor is a closed corporation, a company, or a trust, additional documents need to be obtained, and I don't need to go into all of those. You dealt with it under FICA, the founding statement, the memorandum of incorporation, etc. Sorry, I got some interruption there, but hopefully we're still all concentrating. Okay, the point I'm trying to make at this point in time is that in the case of a trust, you would need to obtain a copy of the original letters of authority or the latest letters of authority and the deed of trust. And I think it's important that you examine the trust deed to ensure that the mortgagor has the power to mortgage its immovable property. It's not enough to just get the resolution signed by the trustees authorizing the mortgage of the trust's property, because there may be a provision in the trust deed preventing the trustees from mortgaging the trust's property. I think this is particularly relevant if the mortgagor is passing a, for example, surety bond, and there have been instances in the past where trust deeds specifically prevent trustees from binding the trust as a surety or guarantor. So just be very careful when registering a bond where the mortgagor is the trust, to ensure that you examine the trust deed to ensure that it has, the trustees have the power to mortgage the trust's property, and also that you get all the trustees to sign the necessary resolution. I mean, if a trust deed specifies that, for example, all three trustees must sign a resolution, then a resolution signed by only one trustee will not suffice. Okay. Okay, so now we've also said that every bank will have their own bespoke set of conditions which the deeds office will not concern itself with. A typical condition is one that says the mortgagor shall not further encumber the property without the mortgagee's consent. So if the mortgagor wants to pass a further mortgage bond over the property in favour of a third party, he'll need to get the consent of the first mortgagee. Now, this is not a formal consent that is lodged at the deeds office, but merely an underhand agreement or permission allowing the mortgagor to further encumber the property. The conveyancer who is instructed to register that second mortgage bond will in any event need to call for the title deed, which remember will be in the possession of the first bondholder, okay, and will ask for its consent to the registration of the second bond. Now, the first bondholder, if they are happy for the second bond to be registered, presumably they will rank in any event as the first bondholder, will probably require the second mortgage to contain what we call a non-prejudice clause. I can't remember if we discussed it in the first lecture, so that's why I just want to deal with it now. So in any event, in your material, you'll get an example, you'll see an example of a non-prejudice clause. And I suggest you learn the basic wording in case there's a question in the exam asking you to draft this. Remember, we said the exam is a drafting exam. There's no prescribed form for a non-prejudice clause, but typically the clause just reads along the lines that, I don't know, the bond shall in no way interfere with or prejudice or affect the rights and preference of the first bondholder. Okay, so I'm not going to go into the wording of a non-prejudice clause, but the point I'm making is that when a first bondholder gives the consent to a mortgagor to register a second bond over the property, and they release the title deed for this purpose, they will probably, not always, but they will ask for the second bond to contain a condition that the second bond will not be prejudicial to the first bondholder. Okay, so I think that's all I really want to say on mortgage bonds that I possibly didn't cover. But before I do, we are going to be dealing with miscellaneous legislation as a separate topic altogether. You've already dealt with quite a bit of legislation that's part of the conveyancing syllabus, the Transfer Duty Act, Alienation of Land Act, Administration of Deceased Estates Act. When we deal with mortgage bonds, the National Credit Act of 2005 is relevant because the mortgage bond could be drafted as a credit agreement. I think we discussed some of this briefly under mortgage bonds. I don't want to, at this point in time, go into detail on the National Credit Act. We can deal with it in more detail at a later stage when we deal with miscellaneous legislation. But I just want to mention that, and I think I did mention this briefly, that in terms of the National Credit Act, certain common law rights may not be waived in a so-called credit agreement. Remember, we talked about the renunciation of the legal exceptions, non causa debiti, errore calculi, etc., de duabus vel pluribus. Well, in terms of the National Credit Act, certain rights cannot be renounced. Errore calculi is one of them, non numeratae pecuniae, and non causa debiti. So in other words, the National Credit Act prohibits the renunciation of those exceptions in a mortgage bond to which the National Credit Act is applicable, and we'll have to then as a credit agreement. All right, I don't, as I say, want to spend too much time on the National Credit Act. We've got quite a lot to cover tonight, so we'll deal with that again in more detail. But also, what is important is that a credit provider must register as such if credit is extended in excess of the threshold, which is currently, I think, 500,000 Rand. Okay. Failing which the agreement would be null and void. I think there's a case law where a loan was granted by a creditor to a debtor. The creditor did not register himself as a credit provider, and as a result, the court held that he couldn't recover the debt. I have it at the back of my mind. I'll try and get more details of that case going forward. All right, so that's enough said on mortgage bonds. I think let's go now on to the chapter dealing with disposal of mortgage bonds. I think it's chapter 16 of your notes. I'm not sure the heading is the correct one, disposal of mortgage bonds. We're not necessarily disposing of the mortgage bond. We certainly are dealing with the mortgage bond. And really, it's the consents that a mortgagee has to provide. I think I mentioned once a mortgage bond has been registered over immovable property, it's virtually impossible for the registered owner to deal in any way with his property unless he has the consent of the mortgagee. And in most instances, the mortgagee will need to consent formally, and that consent, as I say, in most instances, will be a prescribed consent document. Prescribed form MM is the typical prescribed form for consents by a mortgagee. And I just want to go through the most common consents that you will be required to obtain. In the previous lecture, as I said, you're putting on your hats as the bond attorney acting for the mortgagee. I think in this lecture now we're putting on our hats as the cancelling attorney, acting for the bank or bondholder who is required to provide consent to an action by the registered owner. Now, of course, the most common consent that a mortgagee is required to provide is a consent to the cancellation of a registered mortgage bond. Okay, as I said, the consent is drawn on a prescribed form MM and is signed by the mortgagee in the presence of two witnesses. And you can have a look at the example that I think I sent you an example, very basic. There should be some in your material as well. It's a very straightforward document. So I don't see you getting a question in the exam to draw a consent to cancellation. Okay. When property is being transferred, obviously an existing mortgage bond passed by the registered owner will have to be cancelled simultaneously with the transfer. So your bond cancellation, which is incidentally lodged in a yellow lodgement cover with the code BC, will be linked as a symbol with that particular transfer. If there is no transfer involved, in other words, the mortgage bond has been paid up in full, or there's a switch bond and the registered owner is moving his bond from one bank to the other, then you will obtain the title deed, and you as the cancellation attorney will lodge the consent to cancellation along with the mortgage bond, along with the title deed that will need to be endorsed to the effect that the bond has been cancelled. Okay, so fairly straightforward when you're consenting to the cancellation of a mortgage bond. You're either doing it solo or similar with the bond attorney or similar with the transferring attorney. And we talked about the symbols briefly last time. Note also that if the mortgage bond to be cancelled has been lost or destroyed, it's not necessary to obtain a certified copy. The mortgagee must comply with the provisions laid down in Regulation 6811, and we'll deal with this later this evening on miscellaneous applications. Okay, so that's the consent to cancellation. Then we come to releases. Okay, so now where a mortgage bond has been registered over two or more pieces of land, the mortgagee may consent to the release of one of the pieces of land from the operation of the mortgage bond. Okay, once again, the consent is drawn up on Form MM. The operative wording will be, do hereby consent to the release of Earth 201 Johannesburg Township from the operation of the aforesaid mortgage bond. Okay, it would also apply, for example, where the registered owner subdivides his property and wants to then sell off the subdivided portion, let's say portion 1. His property is mortgaged, he wants to sell off portion 1, and he will ask the mortgagee to consent to the release of portion 1 from the operation of the bond. The bank will probably consent, and if there's insufficient equity left in the remainder, may require the mortgagor to pay into to the mortgage bond. Okay. It's possible that if a mortgage bond is passed by 2 or more mortgagors to release the property and the mortgagor from the bond. In other words, the mortgagee can be asked to consent to both the release of the property and the mortgagor from the operation of the bond. Okay, the other co-mortgagors will have to consent to this release. I think this would most often apply in the case of a partition transfer, for example. So where they're joint owners of an immovable property or properties, and they agree to partition or redistribute the property amongst themselves so as to become individual owners of a defined portion of that property in their own names. Okay, sometimes a subdivision will be required, so releases, you would get the mortgagee to consent to the release of one of the properties and the co-mortgagor. Incidentally, I have had some requests from you to go over some of the things that have been covered up to now, partition transfers and others. I think I'd like to set aside towards the end of the course to review and go over everything. So please keep those requests coming in for what you would like us to consider or discuss, and we'll have a revision exercise and cover everything again. So certainly we will go through points where you want us to go over everything. All right, so that's cancellations, Form MM, releases, Form MM. When do you release? When you're transferring a portion or one of the properties away from the bond. Part payments and reductions in cover. Okay, when do you use a part payment or a reduction in cover? Let's assume a mortgagor has an ordinary mortgage bond registered over his property for, say, 500,000 Rand. He's paid off 250,000 Rand, and he owes the bank 250,000 Rand remaining. He can, in terms of the Deeds Registries Act, if he wants, register or get the bank's consent to the registration of what is called a part payment. A part payment is where you have an ordinary mortgage bond. Remember, an ordinary mortgage bond is one that does not secure a fluctuating state of indebtedness, and you cannot re-advance under an ordinary mortgage bond without registering a further bond to secure that re-advance. Re-advances under an ordinary mortgage bond are not secured, and therefore you would register a second bond. If you wanted to register the fact that you've part paid the capital sum, you would request the bank to consent to the registration of a part payment. If the bond that is registered